Hi, I'm attorney Gregory Dell, joined by attorney Cesar Gavidia, and we're going to talk about California long-term disability insurance claims. And Cesar, specifically, you're barred in California, which is a tremendous accomplishment just to pass that bar, but you've been practicing there for many years. And we handle claims all over the country as you do, but specifically, the majority of your claims that you see and the people you speak to tend to come from people who are in California or may have worked in that area and things like that. So.
Yeah.
I want to talk about a little bit specifically of what someone should expect in California with their long-term disability insurance claim, because it's different. Even though it can be federal laws, it can be state laws that apply, whether it's an individual disability claim or a federal disability claim. And the majority of what we see are these ERISA-governed disability claims, but California is a very favorable market generally, or jurisdiction as we call, for their residents, maybe. So we'll get into that. But
Yeah.
what comes to your mind when you think about why it's advantageous for somebody to have a claim in California?
Yeah, like you said, California is a very favorable jurisdiction or state for someone who isn't insured in general. But in the context of what we do, in the cases that we handle, and group long-term disability, ERISA cases, and even individual disability cases, California has really gone a long way to protect its insureds and to protect the citizens of its state against practices by insurance companies that sometimes are not so good. So, for example, in terms of what someone can expect through the initial application process and appeals process, probably they really wouldn't expect anything that's too different if they filed anywhere else. That's not where you're going to generally see where the big differences are. Might an insurance company tread a little more carefully with an insured? Are they going to behave so brashly? Well, it depends. I don't think that necessarily they're always thinking in the back of their minds that, oh, well, we're in California, we better watch out. They have, greater protections here than they have in other places. So we still see a great deal of wrongful conduct, or if people use the term bad faith, conducted by insurance companies in California. But where we really have the advantage and where it's important to have California, disability insurance lawyer involved is at the point where your claim has been denied, where they've potentially already conducted themselves arbitrarily or wrongly, and they've denied your benefits when you're entitled to those benefits. And the reason that you still have to go through, in an ERISA disability claim, you still have to go through an appeal process. It's still important to submit all the pieces of supportive evidence into the administrative file, into your appeal. It's important to have a comprehensive appeal. All those things are still true even in California. But what is really advantageous or a benefit to the insureds in California is that insurance companies generally, if the policy has been issued and delivered there, whether to the employer or to the individual, the insurance company does not have discretion in terms of the decisions that they've made over the claim. So what that means is that if it has to go beyond the appeal stage, and now you have to go to litigation, in many states across the country, the federal court has to basically give the insurance company the benefit of the doubt that their decision was correct. That's a really high bar in terms of a burden to overcome, or a standard of proof to overcome. But in California, you don't have that. So the federal court basically is like a clean slate in terms of how they review the administrative file. They still have to review the administrative file. It's still important that you have put in all of that important evidence, all of the testing, the records, the opinions from the doctors, the testimonials, all of those things. It's still important to include in that administrative file because the court's going to be kind of held to that administrative file when they're doing the review. But they're no longer affording the insurance company that benefit of the doubt standard of review that they get in many states.
Well, that's powerful.
Yeah.
I mean, that's pretty amazing because, you handle cases all over the country, say Florida, for example, where the state has not abolished what's called the discretionary clause, which is in the policies which you just mentioned a second ago, which says that the company has the opportunity to make a claim decision and interpret the terms of the plan. And by doing that, that says to the court, hey, look, this administrator, insurance company, had discretionary authority, and now, judge, you have to apply this particular criteria, where first you have to determine, is the claimant disabled or not? Okay? If you find they're disabled, if you think they're disabled, then you go to this next step to determine, did the company act reasonably? But in California, if the judge finds in an ERISA-type denial, long-term disability group employer provided benefit, that the claimant is denied, and the judge says, you know what, I see that obviously you filed a lawsuit because the company said you're not denied. You filed a lawsuit. If the judge says, I think you're denied, it's over. Right. As opposed to this whole world of case law that we know exists where the judge has determined, well, was their analysis reasonable? It doesn't matter.
Right.
Judge says you're disabled, it's reversed, benefits reinstated, potentially attorney's fees paid to the, to the lawyer, which helps out the claimant tremendously to get that paid. And the claimant's back on claim.
Right.
So California is really one of the few, I think there's only, 15 jurisdictions maybe 15 jurisdictions in the whole country where there is no discretionary clause and the judge has clean hands to determine what's going on.
Right. And I think it's important, for folks out there to also understand, it doesn't mean that your lawyer necessarily has to reside in California or be there physically.
Right.
They just have to be licensed in California, or at least know those nuances with California law and how they'll treat a denied ERISA disability claim. That's what's really important.
The other thing that I think is really favorable for California disability insurance claimants is the definition of disability, specifically total disability, is somewhat different. And can you talk about how they add this reasonable continuity clarification that we don't find really in many other jurisdictions around the country?
Right. So under California law, under their insurance code, they've kind of rewritten the definition of total disability. And what you'll see in the disability policies is that the language, will define total disability. Let's say it's the inability to perform the substantial material duties of your own occupation. But California law essentially revises that to say with reasonable continuity. And what's important about that is that, because a lot of insurance companies, they'll look at someone and say, well, we think that you could still perform the substantial material duties of your own occupation because you could still go to work for, X number of hours a day, or, it doesn't matter that, you might have good days or bad days. But I think that reasonable continuity language really takes that into account. So, California, I guess in their in the legislation when they proposed that and when they ended up passing that was already thinking, well, people have good days and bad days. It's not just enough to say, you're disabled and because of some sickness or an injury, you're just not able to perform substantial material duties. We have to account that person has to be able to be a reliable employee, someone that's going to be able to come to work every day, to put in 8 hours a day, work 40 hours a week. If that's not consistent, and that person isn't going to be a reliable employee, and they're going to have to take time and days off to go to doctor's appointments, that they're not going to feel well, and that's going to certainly affect their ability to remain employed there. They're going to be totally disabled.
Right, and you really have to be a skilled, understand as a California disability attorney the laws in that particular jurisdiction to be able to enforce that, because there's other lawyers out there who are trying to do these cases all over the country and they think it's the same everywhere.
Right.
But it's a totally different game. And then you got to be able to have the follow through to be able to say, yeah, look, if you're not going to pay, if we don't win your appeal, or we don't get your application approved, we're going to sue you, and we're going to sue you in whatever California court we want to uphold the approval of these particular benefits. So I know we spoke about a few things of the advantages of having a California disability attorney and being a California resident, getting access to that are good things. And it's just important for people to know those nuances, especially since we have many, many lawyers at our firm and we're able to cover all these different jurisdictions around the country, and that people need to know they can hire us no matter where they live and we're able to help them. So if you have a claim in California, or really no matter where you live in the country, contact Cesar, myself. We're always available to assist you. We will immediately provide you with a free phone consultation, and we look forward to speaking with you.